my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be discussing on a section 313 of CRPC. So this section gives power to the court to examine an accused, emphasizing on the principle of natural justice, that is odi alteram partem, that no one should be left unheard. Accordingly, the accused may be asked to furnish the information regarding the incriminating allegation against him, which the court accepts as an explanation from the side of the accused. In the case of circumstantial evidence, it is determined whether the chain of circumstances is complete or not. This is provided in case of Kumar Singh versus State of Rajasthan. Now, while looking at the scope and objective of this section, first is to establish a direct dialogue between the accused and the court. Second, to test the veracity of the prosecution case. Now, section 313 of CRPC provides wide scope by accepting information from the accused side after presenting all the evidence of the prosecution proving incrimination of the said person accordingly. Further, while looking at the provisions of this section, we can say in case of Dehal Singh versus State of Himachal Pradesh, the court has observed that the statement of the accused under section 313 of CRPC shall not be administered under the oath. Accordingly, the statement would not be accepted as an evidence under Section 3 of Indian Evidence Act of 1872. The same was with regard to the administration of oath that is provided under Section 313 of Clause 2. So, the purpose of understanding of this section is the Section 313 of CRPC, which deals with the power to examine the accused. In this section, it has been provided that in every inquiry or trial, for the purpose of enabling the accused personally to examine any circumstances appearing in the evidence against him, the court may at any stage, without previously warning the accused, put such question to him as the court considered necessary, shall after the witness for the prosecution has been examined and before he is called on for his defense, question him generally on the case, provided that in a summoned case where the court has dispensed with the personal attendance of the accused, it may also dispense with the examination under Clause B. No oath shall be administered to the accused when he is examined under subsection 1. The accused shall not be rendered himself liable to the punishment for refusing to answer such question or by giving false answer to them. The answer given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry or trial or for any other offence which such answer may tend to show he has committed. Now, in case of State of Kerala versus Rajapan Nair, in this case, we can see that the question was under the clause 1 of subclause A, and under the clause 1 of subclause B of this section is mandatory according to the providing the accused opportunity to be presented with evidence and explanation of the incriminating charges thereof. Further, during the inquiry or trial, inquiry is provided under section 2 clause D of CRPC. Inquiry means any inquiry other than a trial which has been conducted under this code by a magistrate or court. So the term accused has been defined as someone who is under trial and under the examination of the court, and not a person who has been accused under the same jurisdiction of the court in another case. Further, at any stage has been defined as the court has the discretionary power to question the accused under section 313 clause 1 of subclause A at any time during the inquiry or trial, even before a charge has been established accordingly. This has been provided in the case of Emperor versus Jinu Gopal. Now further, there was another case of Subhash Chandra versus State of Rajasthan, where it has been important to note that the accused is provided with the opportunity not to avail the chance of providing the explanation against the evidence that incriminate him in the court. So that's all for the day. Thank you.